in front of you, would you be willing to file criminal charges now against Richard Cordray?
I will tell you at this point in time that based on more than 2 decades as a prosecutor, that a review of the evidence that I've seen thus far would certainly merit a full-blown investigation of those allegations.
And in order for you to be able to make a criminal, you compared this to the Tom Noe situation, and if I recall correctly, none of the people who Tom Noe had funneled money to faced any type of criminal reprimand. Why would that be any different when it comes to Cordray?
I don't understand why that happened. I was not involved in those prosecutions, but clearly the law is very clear that if you funnel campaign contributions through a third party, you know, destroying the ability of the public to know who it is that's seeking influence and access to that public official, that is a violation of law. And I think the violation carries with it up to $10,000 in fines. I'm simply telling you that at this point in time we have allegations, but the allegations are serious enough that they merit a full-blown investigation so the determination can be made whether or not charges should be filed.
You said that the penalty for violating the election law in this way is forfeiture of the ability to take the office?
That's correct.
Is that on the contractor and or their spouses giving the $2,000? Because that took effect in April of '07. It had a look back to January 1st of '07. The contribution was given in January of '07. So one would think it was covered, but the principals listed, like for spouse and child ages 7 to 17, stepdaughter age 25 was not included in the law.
It's for
explicitly
funneling money to others.
It's the
penalty. Yeah.
Okay.
Yeah.
So
the funneling of the money to others and the campaign knowing or being reckless and not knowing that that money was being funneled are two of the basic elements that are necessary to be able to establish and mandate the penalty of forfeiture. And I think the important thing here is that this is precisely what Richard Cordray attempted to do 10 years ago this month when he was running against Betty Montgomery for Attorney General. And I think it's also the same tack that was taken by Mark Dan against Betty Montgomery in the last election in 2006, threatening forfeiture of the seat.
That's never happened, though, is it, in the history of Ohio?
I don't believe it has. We did a quick review of the case law. We could find no cases where that has actually been used. That penalty.
When exactly are you going to file your?
In the next several days.
Anything more exact, like by the end of the week, or?
Well, before the end of the week, certainly.
Today?
Yeah, I just can't tell you that it's going to be 24 hours from as we sit right here. We obviously are moving as quickly as we can. Once the story broke yesterday in your newspaper, we put our heads together last evening. We're taking a look at all the allegations, and we'll put together a complaint, and I would hope to have it filed in the next 2 or 3 days, when I say several days. Certainly before the end of the week.
Will you personally file it?
That's one of the options, and I'm strongly considering that.
And as a prosecutor, would you consider arguing it before the Elections Commission?
That is one of the options, and I'm seriously considering that. And I think that's very important because I think that the taxpayers need to have an opportunity to see what their next Attorney General is like in the courtroom, how he handles himself, how he comports himself, how he puts evidence on, how he makes arguments to the court on legal and factual issues. And I can tell you that when I become Attorney General, that there will be certain high-profile cases that I will personally handle, just like I did when I was the United States Attorney. But the Pete Rose case is just one example. There are certain kinds of cases, high-profile cases, that the public expects their Attorney General to be involved with. And I will be involved, and this is just one indication of one piece of evidence of how I'll do that.
And if this should go to an evidentiary hearing, that could create a situation where you could put Cordray on the stand to testify and question him.
At least initially, we're talking about taking depositions. Many times in administrative type hearings, once the depositions have been taken, full depositions, those are offered as the evidence. Mr. Cordray certainly would be someone we would want to take his deposition. There are others.
Like who?
Mr. Will would be another one. Maybe Melissa Barnhart. I haven't thought much about that yet, but that certainly would be something that comes to mind. There may be others as well. And a lot of times, Sandy, Laura, what happens is that you'll get into the depositions and other names will come up, and then that'll be a basis to take those people's depositions. So we'll be looking at everything and anything that's necessary to uncover precisely what happened.
What actions do you feel like Mr. Cordray should have taken that he did not take?
Excuse me?
Well, as you said in your quote, Richard Cordray's actions simply don't live up to his words. What actions do you feel like should have been taken that were not taken?
I think that, you know, in these kinds of matters, I mean, when this whole climate of pay to play and this whole climate of political corruption that the Democrats ran on legitimately in 2006 that is now becoming an issue here, I would hope that anybody that would be running for statewide office would be continually monitoring very closely their contributions, particularly when you're an incumbent office holder as a state treasurer and you're running for another position. I think it's incumbent upon you as that elected official to make sure that your contributions do meet not only the letter of the law, but the spirit of the law as well. And I understand that can be difficult at times, but we're talking about a situation here where Mr. Will has contributed significant sums of money and his family to Cordray over the last few years. That should have been something that they immediately should have looked at to make sure that there was no problem, particularly when that person was also someone that was receiving more than 37% of the bond trading business in the treasurer's office.
And is this a situation where you get into in-depth discussions with your contributors to make sure from a candidate standpoint?
I think it's one of those things that you have to continually, when you receive contributions, I think you have to be very careful and you have to continually scrutinize those contributions to make sure that they don't run afoul of the law. And I think what has happened here is that, you know, they played fast and loose with the contribution.
Have you had an opportunity ever to question any of your contributors to ask their motives?
I can tell you what, obviously this is my first time in statewide office, but yes, I am monitoring very, very closely the contributions I've received. And I will continue to do that. Now, does that mean anyone's not capable of making a mistake? Of course, I understand that happens. But what I'm simply saying here is that the allegation is very, very serious. Not just the contribution, but the fact that the person or the family that made the contribution saw 3,700% in the amount of business that they did with the state. That ought to run up a red flag. And I tell you what, it will run up a red flag in any kind of finance reports that I have.
Any other questions?